I wonder why anybody would want not to agree with that judgment, a judgment that is as sound, and as visible as anybody can see, a judgment that cannot be faulted in any way, except you want to look at the issue of society and the societal impact, expectation of the society. But if you are talking law, you can't fault that judgment. Very simple. The analogy I want to give is, if a justice of the Court of Appeal goes back to the High Court to give a judgment, how would he sign the judgment? Every judgment is signed and dated. If he signs it as a justice of the Court of Appeal, will it be valid? No. If he signs it as a judge of the High Court, will it be valid? No, at the same time, because he had become functus officio at the level of the High Court. And if he puts a date that comes after he's taking an oath of office as the justice of the Court of Appeal, wouldn't he have lied? So, if you look at that analogy, it simply tells you that as beautiful as it may seem, the provision of Section 3967 of ACJA is completely not in consonance with the provisions of the Constitution and even the provisions of the law that set up the Federal High Court, which is Federal High Court Act. But even if you can say that the Federal High Court Act is at the same level with that of ACJA, but of the Constitution, which is the ground norm.
Are you saying then that the judge who delivered that judgment wasn't aware of this, or he just took advantage of it?
The judge is not only that judge, because they acted based on the provision of Administration of Criminal Justice Act, that's Section 3967.
Yeah.
So, 396 subsection 7, which requires that, which provided that if a judge has had a matter at the level of the High Court and the judge is promoted to the Appellate Court, which is the Court of Appeal, that the judge can take a leave, which is an administrative fiat from the President of the Court of Appeal, to go and conclude such matters. It's a beautiful provision, but it runs against the provisions of the Constitution. And in any way and manner, any law runs against the provision of the Constitution, that law becomes invalid to the extent of such inconsistency.
What then was the intendment of that provision in the first place?
The intendment of that provision, very good question. The intendment of that provision was to solve an age-long problem that has bedeviled administration of criminal justice. And what is it? Tardiness and very slow pace of the wheel of justice. A situation where a matter takes off at a point, the judge gets transferred or elevated or dies or just discontinues the matter in any way, manner or form, the matter starts de novo. That means it starts afresh. Assuming, like in Orji Kalu's case, the matter took about 11 years. Assigning it back to another judge, you don't know how long it will take again.
So isn't that what's going to happen now?
Of course, that is the only option.
So
and that's the only option.
Means what? The intention was defeated?
Intention was defeated by the clash with the Constitution.